Welcome once more. We will continue with the fifth Forum on Environmental Justice as organized by the Santiago Forum. And now we will hold the second panel, but that is called Constitution and Socio-Environmental Conflict. The moderator will be Ms. Francisca Soto Monteverde from the Second Environmental Court. Thank you. Good afternoon. We'd like to welcome you all to the second panel of the fifth International Forum on Environmental Justice as organized by the Santiago office. As we already said, this we'll be talking about constitution and social environmental conflict. We'll be talking about the environment, its protection, its value in modern constitutionalism. We will also hear about how the constitution may give the structure on how to match environmental problems such as water, air pollution, or climate change as a transnational issue. And finally, the ideas here exposed will allow us to hold a debate for Chile that is really very much in force. Each speaker will have 20 minutes, and afterwards we'll have a Q&A session. This is a special panel because, first of all, we will give the floor to Antonio Benjamin, and afterwards you will be able to ask him immediately after he finishes his presentation. So we will immediately give the floor to Luis Antonio Herman Benjamin. He is a minister from the Brazilian Higher Court. He is founder of the Environmental Court, and that is an organization that joins judges, chief justices, and judges from the rest of the world having to do with environmental issues. He was graduated from Rio de Janeiro Federal University, has a master's degree from Illinois, and he has a PhD from Rio Grande do Sul University. I immediately give the floor to Judge Antonio Hernan Benjamin. Thank you, Madam Chief Justice. I would like to, first of all, thank the invitation for me to be here. I have participated in these environmental fora as of the first one that was held. Not always physically, because nowadays we have technology to assist us. And as I said, it is indeed quite satisfying for me to be here with you physically. I thank the court and its chief and Mr. Lira, as well as all of the people who belong to that court. Now, this has to do with an important topic, and in 20 minutes, I'm afraid we don't have that much time except to give a general idea of the situation. But I do have other colleagues who will be analyzing different items related to this very important topic. Let me first of all say that we're not just talking about a dogmatic topic, but one that has very important effects in the system as a whole. The regulatory model of a country depends on the regulatory model of its constitution. This is something that we often forget. We all look into the side, especially what is below the Constitution. And if we have time, we talk about the Constitution. But this is kind of a side event. And in Latin America, though, this is change, and because we must face this change. And this is the starting point. And it's the utmost important for everything we do, not just in environmental law. I could talk about the benefits and the risks of constitutionalizing the environment, but I don't have time. I will very briefly go through the benefits of constitutionalization. I wrote an article that Professor Jagger can circulate And that was a long article that I wrote 10 years ago about this same topic. I think it's titled The Environment and the Constitution and the Equalization of Constitution. It was a play of words, but that was the idea. Placing the environment in the Constitution, but at the same time giving an ecological nature to the constitutional text. There are multiple benefits involved. I will just mention those that I believe are most important. I have talked about the substantive and formal benefits. Among the substantive ones, first of all, for me, there is the duty to protect the environment, not as much as the right. We judges have the issue with interpretation of rights, but we don't have that much problem with interpretation of duties. If there's a duty, well, then it's done, and I will apply those duties. Now, the constitutional text, including the current Chilean constitution, and I won't talk about the constitution that was not passed at the plebiscite, but there is in the current one, there is a constitutional duty, not infra-constitutional, not to destroy or degrade. That's the basis of it all. Secondly, as a benefit, and we will see that the Chilean constitution, the current one, has it. And there we have the equalization of the property right. All of the problems that we are facing in environmental law stem in the understanding today that is completely wrong on the property rights, especially private property. Thirdly, many of these constitutions, including the Chilean one, talk about a fundamental law. And here there are different terminologies and how that fundamental right can be expressed. But it is the right for a healthy environment. The UN has also approved at the General Assembly a text precisely on this topic. Fourthly, and equally important, constitutions that care for the environment give legitimacy to the regulatory state role. And that is no minor thing, because in the past, or just a little while ago, we were discussed on whether the state could rule or not the economic activities, especially those that do have an impact on natural resources. And besides, something that I won't deal with, but to find out whether this would be or not an indirect expropriation. But this is no indirect expropriation, because the protection of the environment is part of the Constitution as a duty, so it's not something that is foreign to property rights. It is a part of the gene of it, and the Chilean constitution system also recognizes the property right only if it protects the environment. It is not external but internal. As a general rule, we're talking about not creating indemnity for indirect exploration. Another benefit is the reduction of discretionality, administrative discretionality, because we used to say that this was all part of the technical discretionality of the manager, but not anymore. There is discretionality, but it is an ecologically limited one. And finally, there is an extension of public participation, as we heard previously. And I could continue with other benefits, but we just don't have the time. Let us take a look at the formal benefits. In law, we know that they are as important as the substantive ones. Often, the judge finds it even important, and it's the distortion, by the way, the system on the formality. For example, to annul any kind of authorization and over the merits of the balance of everything involved. The first formal benefit that I have identified is the maximum visibility and importance of the environment. If it's in the Constitution for all Catholics, why then we're in paradise? It could be a rhetoric, utopic paradise, but still we're in paradise. And that is really the best of the best situation of, or the best regulatory hierarchy, if possible. Evidently, this visibility has to do with something that is not underground and that perhaps only the experts know about. I repeat, this is at the top of the regulatory pyramid, but this preeminence means that it comes first. And as of this constitutional text, we will be able to interpret all other infra-constitutional rules. The second formal benefit that I will quickly mention has to do with regulatory security. We know, but this also involves a risk. We do know that if we place something as part of the Constitution, there will be a differentiated quorum for making changes, contrary to a regular, ordinary law. And thus, we create a certain kind of regulatory security. In my country, we've tried to change the Constitution often to reduce certain constitutional warranties, but it wasn't passed. But it could have passed if it was, we're talking only of a guarantee in ordinary law. And the third one, which is quite dogmatic, but is also practical in its nature. My colleague from the Constitutional Court is here. And with constitutionalization, we have added to the paradigm of what is legal and constitutional. This opens up the road to the Supreme Court and to the Constitutional Court, at least in other countries, as in Germany and Brazil as well. Finally, there are others, but I don't have the time to go into them. Placing the protection of the environment as part of the Constitution is useful to reinforce everything that is for the environment, because there are no longer rules that come from a dream of legislators. No, it is already part of the constitutional text. When I talked about regulatory security, let me say that there are also risks involved. We have a boomerang effect here. When we maybe be safe over there at a certain point, and which is excellent. If we have a good regulatory text, if it's well done, if we have an imperfect text, then it will be very difficult to bring in change. And something that changes as much as the protection of the environment, that can bring in complications. Thus, we must work on it. Constitutional changes must be done by the experts. We must have the correct science. In the Brazilian Constitution, for example, we used to follow our brothers from Otum, the experts know about this. They were very much in fashion and during the 60s and the 70s, and their books were adopted by all universities. It was translated into Portuguese as well. But they talk about ecologic equilibrium, and that became a part of the Brazilian constitution. Well, we know that the environment is never fully in equilibrium. It is a dynamic equilibrium we're talking about. The need for the Brazilian courts to do something. And they said this is not a static equilibrium, it is a dynamic one. On other occasions, the courts and the judges are unable to correct what is already so wrong as part of the Constitution. And I won't mention cases of constitutions that are very badly drafted from a legal standpoint, as well as from the inclusion of the fundamental concepts that have to do with ecology and earth sciences. And let us now go to the techniques adopted by the Constitution. And by the way, this is a very quick outlook.
The first technique most used is of the fundamental rights. This is the technique used by the Constitution of Chile. Another technique, very common, and sometimes only this technique is used, that is the use of constitutional duties, obligations. And frequently, this technique is poorly used because it places the duty on the state. We know that the state has the duty to protect health and other essential values of society, the most important of which is to have that duty on the enterprises and all citizens. The third technique for us, judges, is perhaps the richest of all, is the technique of principles. And principles that sometimes are not explicit, but implicit in the constitutional text. And so it is up to us, judges, to identify these principles and then elaborate jurisprudence for the principles to become something that is directly connected to the constitutional wording. There are constitutions that adopt also the so-called public binding principles. Others that are the weaker constitutional norms that adopt open public programs, very difficult to implement judicially. And lastly, there are many constitutions with constitutional texts that include and explicitly foresee instruments for the protection of the environment, such as, for example, the system of permits, protected areas, environmental impact studies, criminal sanctions, civil sanctions, administrative ones. There's a bit of everything in the constitutional text. And the last 4 minutes I have left, I will speak of two principles, because one of these is directly in the constitutional text of the Chilean constitution. And when I was speaking to my colleagues at Chilean events, and they used to say to me, but this is not in our system. And I said, but how isn't it? It is very clear in the Chilean system. It is a beauty to talk about the normative systems of the others, because if you are correct, that's excellent, but you have just discovered Potosí, the mines. If you are wrong, there's no problem because you're a foreigner. But I believe I am correct. And, well, I am very arrogant, I accept it, but let's see whether I am or not correct. First principle, the principle of the ecological function of property or ownership. And Alejandro recalls this very well. He's here sitting down when I used to spoke of the environmental rule of law, and you said a few words on the ecologic function of ownership. And now I'm going to say it in a more explicitly manner with the constitutional text at hand. Article 19.8, the Constitution of Chile guarantees, open inverted, but the right to live in an environment free of contamination or pollution. The clear text of the technique of the fundamental right. And we could discuss what is contamination or pollution, all right, but at some other time. If contamination is degradation, well, what is it? The Constitution moves on. The law may establish restrictions, specific restrictions to the enjoyment of particular rights or freedoms in order to protect the environment. That is the ecological function of ownership, said openly. Because between determined rights or freedoms, one of the most important is precisely the ownership, the right of ownership, and there is no exclusion. But more openly, Article 1924 says as follows: only the law may determine the manner of enjoying and disposing of it, and the limitations and obligations stemming from their social function. So there is mention here of the social function and attention. This, which one? The social function. Spans as required by general interests. Of course, the environment is there, but the constitutional legislator continued. In general interest of the nations, national security, the utility and health, and here my writing is terrible, and conservation of environmental heritage. Very clear. I would say as clear as the Colombian Constitution, and I believe that you have the Colombian Constitution there, or the Constitution of Brazil. It is more beautiful because it speaks of environmental heritage or equity. This is heritage, material and intangible, tangible and intangible. You could have an entire treaty, and here you could get your doctoral students to do a treaty on environmental heritage and the ecological function of ownership under the current Chilean constitution. But well, and I was going to speak of the principle too, but I have no more time. I'm already 30 seconds over, but Mario is going to speak, and so the delegation is ready, because the first Supreme Court to bring, he corrects himself, in dubio na natura was the Supreme Court of Costa Rica. And then other courts, even my own one, we moved ahead a lot. And this today has direct implications for the protection of the environment, and not only under the norms for direct protection of the environment. I apologize. I have extended myself by 1 minute. I thank you very much. It is always a pleasure to be in Santiago, in Chile, with my Chilean brothers. Thank you. Very well, and so now we have time for questions to Mr. Antonio Hernan Benjamin, based on his presentation. Minister, good afternoon. I would like to ask you as follows. If a new Chilean constitution adopted a legislative technique to include environmental principles, in addition to the preventive and precautionary principles, what other principles do you believe should also have constitutional recognition? Thank you. As I said, often the principles are not directly in the Constitution, and it is the task of the doctrine and of the judges and jurisprudence to interpret the norm and extract the principles. For example, I am unaware of a constitutional text that has the principle of in dubio pro natura, but the ethical principles of the in dubio pro natura principles and the norms are in this constitution. And what you see is a design that, well, that is for us judges to do that. Few constitutions have explicit principles. And in fact, it is not recommendable because principles are often changed. For example, the principle of whoever pollutes pays in the 70s, they used to say, well, if whoever pollutes pays, I pay and I can contaminate or pollute. They say, no, 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 you cannot pollute. If you pollute, you must unpollute and then pay. There are a few constitutional texts that have explicit principles. I unfortunately must leave for the airport. I really apologize, but unfortunately I must leave. Thank you very much. Very well. Then now we will continue with the second panel, and we will be addressed by Carolina Restrepo Herrera, who is the Judicial Law Clerk, Constitutional Court of Colombia. Good afternoon, everyone. For me, it is a pleasure to be with you here today on behalf of the Chief Justice Magistrate, Cristina Pardo. And we thank the environmental judges for the invitation, especially the Minister, Christian Del Piano. Special greetings for other members of the environmental judges and my colleagues at the panel, all colleagues, academics, and experts in these topics. In my 20 minutes as a speaker, I would like to focus on two matters that I consider to be it's important to share here. First, I would like to refer to what the Constitutional Court of Colombia has called the ecological constitution, its meaning, the scope and consequences, and how this lens of the Constitutional Court has allowed the development of content that protect the right to a healthy environment. Second, I will refer to some cases where the court has taken part in order to resolve environmental conflicts in different scenarios. And so with this, I would like to leave you with the relevance of the constitutional court in order to resolve these conflicts, not only from the viewpoint of fundamental rights, but a broader approach as the one that includes the different forms of development of the community involved, the interests at play, and the need to coordinate the participation by various agents of public power and different levels of government. All in all, what I would like to present on this occasion is that the solution to socio-environmental disputes through judicial means are only a starting point to unblock the disencounters among people or entities involved. That is, the judge from the constitutional viewpoint serves to clarify a problem and clarify possible solutions, but ultimately, as defined by the first panel of this meeting, if these orders are not met, the conflict persists, and so alternative measures must be found to reach a solution. Well, this first part, I would like then to elaborate on what the Constitutional Court has said regarding the Ecological Charter or the Green Charter. The Constitutional in 1991 gave rise to the current political charter, recognized that the human person depends on her surroundings and relationship with the nature and other living beings. The collective rights, and particularly the healthy environment, has to do with the relation between human beings and their natural surroundings. And that is why ecology, as a science, among other matters, considers interactions between the human being and the natural environment, and this transcends our legal framework. And along these lines, the Constitution of 1991, contrary to the previous constitution that we used to have in Colombia, has several provisions, or close to 33, that comprise what the Constitutional Court has called the Ecological Charter. Specifically, I would dare say that the essential core of this ecological charter is determined in Articles 79 and 80 of the Political Constitution. These two articles determine the right to a healthy environment and participation in environmental decisions. And the role of the state is to plan the natural resources. However, there are more than 30 provisions in the constitutional that seek to protect the healthy environment and in turn establish competences by different levels of government in order to distribute the laws and also the benefits and resources. One of the implications of this ecological charter is what the Constitutional Court has called, and that the previous panelists mentioned it, the need to understand the social function of ownership. And that is why the court has indicated that there is an economic triptych of rights in the Constitution, comprising the right to work, the right to private property, and the right to freedom of enterprise. And this economic tripod has a social function, but the duty is to ensure the protection of values and social rights, and these in turn we highlight life and ecology. And then the work and enterprise has an ecological function.
Likewise, the Constitutional Court, as of that charter and its provisions, has interpreted its content through different international instruments, soft or hard, and the jurisprudence of the court uses international instruments and documents as well in order to bring in content. Amongst these, I can mention a few. There are many, but the court has used the Stockholm Declaration of 72, the Nature's Charter, UN's Framework Convention, Kyoto, amongst others, Johannesburg, and many other instruments that are more updated, such as what has been brought in by the International Court of Justice. Now, the Constitutional Court has said that the right to a healthy environment has different dimensions. One, in Colombia, is a principle. It's a constitutional fundamental right that is individual and collective that can be demanded by all individuals, and it is an obligation on the hands of authorities, society, and private individuals. And besides, in the clean environment is a public service. In view of these standards, the Constitution brings in concrete obligations for the state. These obligations can be summarized in prevention, mitigation, compensation, reparations, and punitive measures. There are 8 general standards. The state must protect its integrity, safeguard natural resources, preserve areas that are of importance, plan the management and the use of the resources for a sustainable development, having always in mind that restoration, prevention, and the others, preventing the destruction, imposing legal measures, and restoring nature, and the obligation to cooperate with other nations in the protection of the ecosystems in border areas. During these 30 years, the court, with this lens, has gone into the ecological charter, but with different perceptions on how to analyze socio-environmental flows with an anthropocentric, biocentric, and focus. And in the last few years, we have been rather using an ecocentric lens. And now, then, the Constitutional Court has recognized the relation with the nature and the need to encourage stricter protection of the nature. This recognizes nature and its interdependence with human beings has led the court to develop principles of sustainability, prevention, and environmental precaution. This has been useful to solve cases with social environmental issues involved. I won't go deeper into each of these principles, but I will continue talking about a concept that the court has developed. According to the court, we're talking about the fair treatment and participation of all persons, notwithstanding their race, color, economic revenues, and colors in terms of the environment. Thus, the right to the environment and sustainable development brings in a dimension of justice, of fairness, having to do, first of all, the equal distribution of loads and benefits, especially having in mind the vulnerable populations. And the second has to do with the effective participation in decision making amongst the communities that are being affected by the development of exploitation projects that are to be conducted in a certain territory. Here, the court has been clear in that it's important to have in mind the experiences and the cosmovision of the communities vis-à-vis their territory, and not just what the scientific study states. When the time comes for the projects to be built, those that have a relation with natural resources in the community, these standards are not always met by the authorities. These standards are at risk and are not followed. So there are social environmental conflicts that arise. And in Colombia, the court has mechanisms in order to demand the protection of the environment. And these, generally speaking, are popular action and the safeguard. We'll talk about the second, the protection or precautionary remedy that protects fundamental rights immediately. The court, and I start with the second part of my presentation. The court has known of many cases that are well known, and I don't spend much time on this. It has to do with the way of solving social environmental issues from different standpoints. I will here bring to you at least 3 or 4 cases that I believe are important in the way the court has solved the situation, what was found, and then what were the solutions. The first one has to do with Salvaquina. This is a dam at Cauca department involving many municipalities. The construction of this dam started in 81, And when the work was conducted, their regulation demanded previous consultations with the indigenous peoples involved. On that site, they did not consider this differentiated cosmovision that the local populations had and everything that it involved. The construction started, and in 86, the agricultural indigenous Afro-descendant communities that lived there mobilized, demanding of the government to meet certain obligations. And this would be to bring the situation back to the way it was before the building of the dam. Until 2013, the indigenous communities submitted a protection remedy, and they wanted previous consultation, health, education, and residents. Because of the dam, some communities got very much isolated to other cities, making it difficult to have access to health, education, and others. That is why the Constitutional Court, in learning about this, found that the state had not catered for that. They had abandoned the fundamental rights of these indigenous communities. On that occasion, the court analyzed the importance of previous consultation in cases where these resources were to be exploited, and that affects these people from a physical standpoint, in the loss of territory, in the pollution of the air and water sources, as well as social cultural issues. Here there was an additional issue involved. As I said, previous consultation was not conducted. But after 91, the Constitution made it mandatory. So the Constitutional then ordered afterwards a previous consultation to be done involving environmental assessment studies. And that was the decision that was adopted by the court to protect the local communities. The Constitutional Court maintains the oversight to make sure that this is all met. The second case I wanted to bring to you is the Atrato River case. Here, the court learned about a protection remedy on involving different entities from the state, including the presidency of the Republic. And the idea was to stop the intense and large-scale use of different mining extraction means that were unlawful. But several of these activities were under the Atrato River basin, and that affected different communities that depend every day on the water that flows from that river, through that Atrato River. Atrato goes through Echico, and that is one of the wealthiest places of biodiversity in Colombia. It is a large river that is navigable. The rain, very important for all of the communities involved. This was being polluted with cyanide and mercury coming from the mining operations. The Constitutional Court on this award made a very, very lovely decision. The court used a new focus, having in mind the protection of the environment. And the court then said, one of the largest challenges of our constitutional system is to change the idea of protecting the environment because it brings in some kind of profit or benefit. We must change that. We must accept that the importance in protecting the environment comes from the idea that when we're talking about a living entity, as many other life forms, they are subject of individual rights, making this a new must full protection of the environment on the side of the states and all involved. The court then made the decision, and this solution here recognizes the Atrato River as subject of rights, ordering the state and the different state agencies and entities to recognize all of the measures that are needed to reset the condition on that basin, not only on the side of the state, but this should be done with the participation of the communities involved and affected because of that pollution. A group then was set up with the community representatives, and it was called Rio Atrato Community Table. That was the second case I wanted to bring to you. And the third one was a locality in Colombia, uh, lowlands, involving different communities. And much was involved. And this wetland was next to communities involving a lot of cattle raising activities. But all of a sudden, the environmental authorities came over and did not allow the activities to go on because of the wasteland that was set up there. Now, what was noticed that there was deficit in terms of access of information on the part of the communities that would allow them to participate in limiting these wasteland. And the communities just had not been considered. Now, they wanted to see whether these activities that were conducted by the communities were being affected because of this new wasteland that was being created. And the court also set up a series of standards that must be considered for the establishment of these wastelands. Amongst these census, participation of the communities, public hearings, etc.
And so time is running out, so I would like to present the general conclusions of this presentation, notwithstanding whatever questions you may have later on. And I would just like to highlight four things. The first, the ecological constitution or green constitution ensures standards for the protection of the environment and impose government obligations of different levels to ensure or to guarantee fundamental rights and protection of the environment. Undoubtedly, this is a framework for government organizations at different levels. And the second thing of the cases I highlighted very quickly, it is necessary to strengthen the right to environmental participation by communities involved. That is, on account of the deficit of the space, is that often, not always, but we have these environmental disputes because there is insufficient contact with the affected communities and there are no agreements for reparation. And so that is why the environment is affected and the relationship between the communities and their surroundings. The other thing, and to conclude, is the relevance of the constitutional judge that serves to draft diagnosis, corrections, and omissions by the entities that are responsible for protecting the environment and seeks to offset the abandonment created by certain administrative authorities. However, the most relevant or the Colombian experience has been having knowledge of socio-environmental disputes, and that is through judicial mechanisms and protection, it has been possible to recognize and make visible the narratives of populations that are usually not heard by the majority in the traditional fora of democracy. It is only through these means, by these sort of action, that their rights have been recognized and that the agreements have been reached. And with this, I end. Thank you. Thank you very much, Carolina. And so now we will be addressed by Mr. Peter Tobias Stoll, who is now available. The floor is yours, sir. He is a professor of international public law in Göttingen, Germany, and a co-director of the Institute of International and European Law of that same university, and leads the Department of International Economic and Environmental Law. His lines of research and publications cover areas such as international European law, particularly environmental and economic. Professor, now yes, you have your 20 minutes. Thank you.
Thank you very much, Chair. And of course, dear President of the Environmental Tribunal de Santiago, distinguished colleagues, ladies and gentlemen, it's such a great honor for me to have been invited to present some thoughts on this important and prestigious conference. In this panel too, we discuss constitutional questions and socio-environmental conflicts. I've been fascinated really to listen to the debate and to the other speakers already, and I'm very looking much forward to continue this kind of a discussion. I, on my part, have been trusted with reporting to you some aspects of what now is called climate change litigation, and I will do so with a focus on the European region. Of course, I'm aware that the constitutional challenges ensuing from climate change are different in Chile and Latin America from the situation in Europe, but I think that I can give you some information that we can consider together and which might be useful to bring forward constitutional thinking about environmental protection. If I say Europe, of course, I would say that also I do not only include national courts, because here in Europe, because of the European Union and because of the European Convention on Human Rights, we also in a way consider the European EU courts and then also the European Court on Human Rights to form part of our national constitutional systems. And with this, I would like to share my screen to make a bit more clearer what I'm talking about. Okay, here we are. And well, this phenomenon of climate change, I think is much discussed in Europe and also in North America, but it is considered to be a global trend. And of course, the notion of climate change is somewhat political. It has been advanced by civil society groups and then by academia. You might know that the Columbia Law School, and more precisely the 7th Center for Climate Change Law, is hosting a climate change litigation database, which to date hosts something like 1,500 cases alone for the United States of America and something like 600 global cases. And I would not deal with the US cases because I think there this database is rather specific, covering a number of US litigation cases, which are quite specific. But I would like to have a look with you on those global 600 cases, and more specifically some European cases, and I would like to confine myself to the most prominent cases in that database. But let me tell you something before we go into the details about this, what is now called the climate change litigation, as kind of an academic term to cover the phenomenon. And I would say that basically climate change litigation can be understood to be all those cases which are related to climate change, but which are also understood to advance kind of a political advocacy, a political agenda. And that is in a way represented by the case that most of those cases are driven by civil society organizations behind. So we see something like a climate litigation industry where very powerful and sometimes also very rich civil society organizations work together with specialized law firms. And they do, in my view, a very good job in putting together the legal argument selecting the right claimants which really would make a good case. And this is really kind of a legal innovation, I would say. If we look into the emergence of this climate litigation phenomenon, most people would say that there has been a first phase when there was much action against administrative acts. So perhaps action against permits to run a power plant or licenses to do raw material exploration and production, or issues like this. And then, and I will focus on this, there has been a second phase when this climate litigation aimed at actions which governments or even legislators would have to take. And that is, of course, constitutionally the most interesting issue. And then we see also the beginning of the third phase, where actions are taken against enterprises. In this phenomenon of climate litigation heads for entities beyond government and legislation, and that is perhaps particularly interesting. But let me just sketch out a number of those decisions, which are always concerned to be the pioneering cases in climate litigation. And normally the people for some right would say the Urgenda case was a very first and most important case. And it has to be explained that Urgenda is a civil society organization in the Netherlands, and they were bringing a case against the state of the Netherlands, including the government and the legislature. And they were asking the court to order the state, so government and legislature together, to reduce greenhouse gas emissions. And there were a number of arguments behind, and I wouldn't really go into that. But I would like to point your attention, first of all, to the kind of legal claims which were referred to in order to support the case. And that has been human rights, the climate change system, so the Climate Change Convention together with the Paris Agreement, and then in addition, EU law, especially in the area of environment, the Dutch Constitution, and very funnily and fascinating, the case was in effect based on Dutch tort law, so civil law, something which sounds very strange to other jurisdictions in Europe, and I believe also in Latin America, where it would sound very interesting to bring a case against the government on the basis of private law. But indeed, the private law in the Netherlands is such as to support such a case. And it was heavily litigated. So first of all, the District Court of The Hague accepted the claim. And then, of course, there was an appeal to the Court of Appeal in The Hague, which in 2018 rejected the appeal. And then finally, if you want, there was a second appeal to the Supreme Court of the Netherlands, who finally upheld the first judgment of the District Court of The Hague. And that is why the state, in the end, the Dutch state, was ordered to reduce greenhouse gas emissions beyond the plans that the legislature and the government had made before. So this is a very interesting case. For the first time, we see this combination of human rights, of constitutional fundamental freedoms, as has been already voiced in the panel, and then this funny combination with Dutch tort law, and a very, indeed, an outstanding judgment. And if you like, you could then also take the German Federal Constitutional Court's case from March last year as a second pioneering case in this regard. It was based on the procedure of the cancellation of federal legislation. Here in Germany, individuals, but also other state entities, can ask the Constitutional Court to look into the constitutionality of a certain piece of federal legislation. And such a piece was adopted by the German parliament just before, and it was called the climate change law. And a number of relatively young complainants then went to the Federal Constitutional Court, and they made a very interesting argument. They were basically saying that the law was unfair to them as a younger generation because it would not be overly ambitious in the time until 2030. And it was already clear that afterwards, climate change policies and regulations in Germany would have to be much harder in order to meet the targets of 2050. So basically, it was about the question of the proper and just distribution of burdens to overcome climate change between two types of generations. And also very interesting, the rights on which the claim was based were not the environmental dimensions of, let's say, the right to life, to health, or something like this, but it was basically the fundamental freedoms of those young people, even to pollute the environment. And the argument was something like a distributional injustice. So basically, they were claiming to get an appropriate share of also being able to pollute the environment after 2030 to 2050. And they were making the point that the German government, obviously, in its climate change law, foresaw that there would not be very ambitious targets until 2030. So in a way, relieving the actual generation of Germans on the expense of the younger generation of Germans. And that was something which I consider very interesting. And here we can also see the drive of climate litigation, because already a new complaint is pending, because several people doubt whether the German government and then the German parliament did revise the original law in a sufficient way. And I leave it there for this decision, which I consider very much interesting from a constitutional doctrinal perspective. And then I should also report you on the flaws. So on the disappointments in European climate change litigation, and certainly the case Carvalho and others against Parliament and Council before the Court of Justice of the European Union was such a case, because the Court of Justice, so the court and then finally the Court of Justice, denied standing for a complaint which was basically based on life and health, because both courts held that under the so-called Plowman formula, which is a very specific issue in EU procedural law, the claimants were lacking standing because they could not show that they were in a singular way affected by EU legislation on climate change. In the view of the court, in order to have standing against those legislation, you have to show that you are personally affected by this legislation as no one other. And that is what we call in EU law singularity. And that is certainly something which both courts denied, and certainly that was criticized very much. And many people were saying that once again, it became obvious that in the EU system of legal protection, we need a pure and clear constitutional complaint procedure, because the traditional way to come to the Court of Justice of the European Union would be insufficient. But I should point you to something which in a way shows that all my kind of an account is in a preliminary stage, because we are awaiting here in Europe altogether a decision of the European Court on Human Rights in a number of cases. First, Duarte, Agostino, and others versus Portugal and others, and in this case, others would mean practically all other about 40 member states of the European Convention on Human Rights. And there's a second case called Carême versus France, a Swiss case, Verein Klimaseniorinnen Schweiz and others versus Switzerland. And also there's a new German case. And so far as I can see, the European Court on Human Rights has taken all those 4 cases together and referred them to the Grand Chamber. The Grand Chamber, as you know, is a very high and prestigious chamber of the court, which only deals with very particular and highly relevant cases. And all those cases are now before the Grand Chamber, and we are awaiting a judgment. And that is why I'm saying preliminary report on the European situation, because certainly that decision will be very much important throughout Europe in a larger sense, of course, because it's not only the European Union, but it's the European Convention on Human Rights, which, as you know, has far more members than the European Union does. But let me quickly go into 2 cases which show this kind of a third dimension or the third period of climate litigation, which is headed against private entities, enterprises, companies. And here the leading case would be Milieudefensie and others versus Royal Dutch Shell, which is a Dutch case heard already by the Hague District Court. And the complaint has been that Royal Dutch Shell, so this oil company, should reduce its global carbon emissions from its 2019 levels by 45% by 2030. So basically, what this claim does is to impose on a private company kind of emission reduction targets as normally set by government programs, be it of the European Union or be it of its member states. So that is very interesting, because what we see here is basically a political agenda reducing carbon emissions set on a private entity on the basis of a composition of constitutional claims, so would be life and health, and on private tort law. And in the Hague District Court, this Milieudefensie was successful in its claim, but it should be noted that over the summer, Royal Dutch Shell filed an appeal, so we are not yet sure what will come out of this case, which would be very interesting, because we could see then that this climate litigation also heads and addresses private entities. And the same is true for a German case, which is Saul Luciano Liua against RWE. And that is a farmer in Peru, which has brought a complaint in German civil courts against RWE, which is one of the big electricity companies in Germany, for damages under German nuisance and tort law. So under German private law, as the same kind of legal basis as you would have between neighbors within two real estates in Germany. And it is technically about the likelihoods of floods in Peru, because in climate science, it can be really nicely shown that the likelihood of floods in Peru will be aggravated with climate change. And bringing such a private law tort or nuisance claim in German courts for something which happens in Peru is, of course, quite innovative. And that is why the first instance, the municipal court in Essen, rather declined the case. I think the judges were not very eager to take on this case, but then it went in appeal, and the district court in Hamm said in principle it cannot be foreclosed that German enterprises can be held liable for climate change related damages that they will cause by their very operations in other parts of the world. And that is why the district court in Hamm opened the stage of evidence, and the whole court and the parties were traveling to Peru in order to understand, in order to take evidence about this case. And still, of course, the final decision is pending and would then, of course, be also subject to a further appeal to the German Federal Court. But those two cases are the ones which are the most advanced in addressing private enterprise for climate change. So I could have explained to you much more climate litigation which is going on, but I think for the sake of time,
Professor Peter, can you hear me?
Because I think those cases are the most relevant in Europe, the ones which are always discussed. And let me come to my conclusions about the achievements, relevance, and limits. I would say the achievements of this climate litigation is important legal clarifications. We have seen very much doctrinal development, both in the Uganda and in the German Constitutional Court's case, and also in this RWE case. And also, and that is the second purpose of this kind of a litigation, you see enormous public awareness. And of course, the civil societies organizations are also able to raise money in order to go on with this litigation. And this litigation, of course, as I tried to explain, takes place in a much more professional way than you would have it otherwise. But of course, I would also point you to the limits as I see them. While certainly the courts can call on enterprises, they can even call on governments and even on legislators to stop emissions. That is true, but they cannot in themselves creatively point solutions, how to reduce emissions, whom do we say to stop industrial or household activities, what kind of a compensation has to be paid for this, and all this rests a task for politics, not for the courts, and that is possibly a limit. And then secondly, I wanted to point you to a legitimacy problem, because I heard that you were talking about legitimacy already in the other panel and also in this panel. And I think we have a problem here. If, for instance, the courts would engage in something like a very progressive, proactive way of adjudication, we would see legitimacy problems, because then the people would say, what can judges and courts say about the environment and about climate change? That is something that policymaking has to address. That would be a problem. But the second problem also is legitimacy in terms of justice. So, for instance, if enterprises are targeted, of course, the civil society institutions behind this kind of proceedings target certain enterprises with a with a well-known name and which are sufficiently large. And that would not be very unfair, in my view, if you look into other industries and other businesses which also contribute to climate change. So targeting only one or two companies by country would tendentially be very unfair to them as compared to the industry or businesses altogether. So I see a lot of achievements and relevance, but I do also see limits in this kind of a new development, which is called climate litigation. And with this, Chair, I'm happy to give the floor back to you. Thank you.
Muchas gracias, profesor Peter Tobias. Ahora es el turno del profesor Mario Peña Chacón, quien es profesor de la Facultad de Derecho de la Universidad de Costa Rica en los módulos de Derecho Ambiental, Derecho Público y otros de la Universidad de Costa Rica. Es coordinador de la Maestría en Derecho Ambiental de la Universidad de Costa Rica y es autor de numerosas publicaciones en materias de Derecho Ambiental.
Muy buenas tardes. Primero que todo, agradecer al Poder Judicial y a los ministros y la ministra del Tribunal Ambiental por esta invitación a formar parte de esta mesa que realmente ha sido de lujo compartir con juristas de tan alta talla. El tema que les traigo es el que están viendo en pantalla, el derecho humano al ambiente como el actual y principal catalizador del litigio ambiental y el núcleo esencial de la justicia ecológica del siglo XXI. Para arrancar, yo siempre le digo a mis estudiantes que estamos viviendo una neorrevolución jurídica ambiental. Y cuando hablo de neorrevolución es porque hubo una revolución previa. Bueno, esa revolución previa la tuvimos durante los años 90, especialmente luego de la cumbre de Río 92 y los tratados internacionales que emanaron de esa cumbre, como el Tratado de Cambio Climático, el Tratado de Diversidad Biológica y el Convenio sobre Desertificación, entre muchos otros. Luego como que nos dormimos un tiempo y como que ahora nos empezamos a despertar, y este despertar arranca tal vez en los últimos 10 años, de la mano de los informes del relator, de la Relatoría de Derechos Humanos y Medio Ambiente de Naciones Unidas, de la mano de los Objetivos de Desarrollo Sostenible, especialmente su objetivo 16, tenemos que ponerle mucha atención, de la mano del sistema interamericano.
American system of human rights, and here we're talking about the consultative meeting of 2017, such as the Chacon versus Argentina of 2020. And today we are thinking and waiting anxiously of what could come from Peru, and that at any point the Inter-American Court will reach a decision. Now, within this new situation, we have the Escazú Agreement as the instrument the most advanced by Latin America, our region of recent years, the most important environmental democracy tools coming from our region. And lastly, two very important decisions. October 2021, the UN Human Rights Council, June 2021, and then in 2022, the UN General Assembly recognized the right to the environment, recognized by 156 states of the total 193 members of the UN, at least at constitutional level, legislative and regional treaties. Let's recall that this forum explicitly recognizes it. The core, the content we will find or has been already developed by the multiple reports by the UN rapporteur on the environment. I would recommend that you read these reports. The American system has been a great help, especially with in 23, and then La Cola in Argentina with the resolutions by the Human Rights Council and the General Assembly of 2021 and 2022. These have helped us to give content to this sui generis human right. And now I will tell you why I say that the environmental human right is a sui generis right. It is different to the others. What is the content? Clean air, safe and sufficient water, sanitation, healthy and sustainable food, environment free of toxics, safe climate and healthy ecosystems and biodiversity. Exactly what the previous speaker was talking about. The issue of climate litigation goes hand in hand with the right to a clean, safe, and sustainable environment, healthy environment, which prevailed in the UN after the resolutions of the Human Rights Council and of the General Assembly. So we are saying that we are facing a human rights that has collective connotations as well as individual ones. In turn, this is an autonomous right, but also a right that coexists, influences, ecologizes other human rights with which it must coexist and survive in perfect harmony, because it's one human right cannot squash another human right. No, they must coexist. And when we have conflicts, as the Minister Herman was saying, what arises is the social function, the right to ownership. So as I was saying, it is an autonomous right and also a right that we could classify as environmental human rights in plural, substantive and environmental rights, procedural. This is a human right that it's and it is human as well as not human. And when we're talking about the human being and the those who will, the recipients are the present generations as well as future generations. And this will see as a human right that protects the environment and nature and its components as legal interests in themselves with total independence to human interests. And so the Inter-American Court says that the environment and its elements are protected even in the absence of certainty or evidence of risk to individuals. And so this is a change in the approach, in the application of human rights. In this case, the right to the environment, moving different to a classical anthropocentric approach. And now we're saying that it could be ecocentric, biocentric, or geocentric, as Ricardo Ruiz said in Argentina. I was saying that environmental human rights could be described as substantive, procedural, of access. Among these substantive ones, we find the right to life, to health, drinking water and sanitation, the right to food, the right to housing, the right to ownership, and even the right to peace, among so many other human rights, and that, such as the environment, must coexist in perfect harmony. And so we also have environmental human rights in terms of access or procedural covered by the Escazú Agreement, and we have significant development in terms of access to environmental information, the right to public assets and access to justice, participation, and information. So Article 8 of the Escazú Agreement is very relevant. Now, when we can resort to the 16 framework principles, I always recommend seeing these framework principles of human rights and the environment developed by the UN rapporteur for the environment and human rights. The report was joint between John Knox and David Boyd, the current rapporteur. But they make this classification between in substantive, procedural of human rights, and they also include another category that is special, which is in favor of persons and populations living in vulnerable situation, which allows me to touch on the way that we must address this relationship between the human right to the environment and other human rights, and this is based on the rights approach. We cannot leave anyone behind, which is very important when we're going to apply this to concrete cases, the right to the environment, but also we have the phenomenon of the ecologization, this interaction between the human right to the environment and other human rights with which we must reach a balance in order to apply them to concrete examples, and maybe we'll have to restrict one right a little bit based on the environmental right to ownership and so on. So we will have to see how this works. And this has to operate with all human rights. As to the human rights-based approach, it focuses on the needs of those most affected and increases accountability by the state and the private individuals. This is very clear when we review the Escazú Agreement. All articles under the Escazú Agreement have a special reference for populations who are living in vulnerable situations. And it's these populations, we have indigenous people, girls and boys, persons living in extreme poverty, minorities, persons with disability, women, coastal and small island communities, that they are very, very vulnerable to the impact of the crisis, of the climate crisis that we're experiencing. Without this list being a final, these are just the ones that we see under the Article 23. And there's another on populations living in vulnerability. We also have the phenomenon of human rights greening. Now, this what it implies, and the example I try to give is that let's imagine that the right to the environment is a solar system, and then that's the sun, and all other human rights orbit the sun. Each human right related by the environment is enlightened and heated and warmed, if you like, by these other rights, and helps them to apply them differently. This is an explanation of this phenomenon of human rights greening. The right to ownership, the right to water, so many others, right to housing. And so what we need is to apply them in the light of this greening of human rights. Now, why do we say that the right to the environment is a human right? Well, now, this we owe to the progressive advances made by the International Court of Human Rights and the La Cajoja against Argentina ruling. The Inter-American Court made it very clear that contrary to other human rights, the right to a healthy environment protects nature, and direct protection by the legal system through a human right. And even in the absence of certainty or evidence of risk to individuals, and not only on account of the effects of degradation that the degradation may have on other human rights, but also because of their importance for other living organisms. And an intrinsic value is given to the environment, the components of the environment, and clearly says that they are beneficiaries of direct protection, human right. And so we are saying that the right to the environment is a human right different to other human rights, because it breaks with this paradigm in that human rights are of human beings, for human beings, and by human beings. This is the first human right conceived, thanks to the Inter-American Court, no longer just for current and future human beings, but the human right to the environment is conceived to operate directly as a legal right in themselves as the beneficiary of protection with regard to the elements of the environment and nature as a legal interest. It's as such. And so this is a new approach, as our Colombian colleague said. This is a new way of seeing human rights, especially the right to the environment, with the lens that we could say as ecocentric, geocentric, and that will depend on each system. And especially, it is speaking of the interpreters. And that is why I always mention the relevance of interpretation, hermeneutics in environmental matters. And we need to have this change in paradigm from going from being anthropocentric. So this new inter-American perspective, every present and future human being, as well as other living beings, are recipients, subjects, interests of protection by human rights environment. Some examples of recent rulings that have applied this approach thanks to what we could call greening of the courts, cross-fertilization among courts. But in this case, it's dialogue between the Inter-American Court and high courts in the region as of 2017. There's this ruling, which is a jewel by the Supreme Court of Justice of Mexico, known as the decision of the coral reefs of Veracruz. And it makes it very clear that this right, the right to the environment, addresses not only the right of human beings to live in a healthy environment, but also protects the value on account of its value in itself. And it says that the idea of the obligation prevails over the other one. So the scope of protection of this human right seeks to regulate human activity to protect nature, which implies that its essential core of protection goes even beyond the most immediate objectives of human beings. The right not only serves the right of human beings to live in a healthy and dignified environment, but also protects nature for the value it has in itself for present and future generations. And now, the Mexican course has provided this analysis between these two approaches, the anthropocentric and the ecocentric one, and tells us that nature rests not only on the use that this represents for the human being, but seeing the human being as an entity that protects itself. And this is very clear by the Inter-American Court, reflected in other parts of the region, is of the Constitutional Court of the Supreme Court of Justice in Costa Rica. It's very, very recent, and through it directly and autonomously deals with an aquifer, which is at the risk of being contaminated. And the order says that it addresses and resolves the problem that affects the Mora aquifer. So the order is to attend the aquifer as a direct beneficiary, to be protected by the human right to the environment that was violated with this case. And so the Costa Rican Constitutional Court said that the subject of protection of the environment transcends the human being because it shelters the various components of nature due to their transcendence to preserve the existence of live organisms in general, regardless of their utility for human beings. So this is also another sentence of 2021 and once again, in this new approach, hand in hand with jurisprudence by the Inter-American Courts of Human Rights, they says that the block of environmental legality to protect the environment, in addition to ensuring its enjoyment by present and future generations, so that the block of legality must protect the environment in addition to ensuring or protecting the enjoyment of these rights by present and future generations. And this, in the case of a possible conflict between two human rights, the right to drinking water and the right to the environment, social conflict, and so the chamber resolved that they say, consequently, the court must frame the discussion of the action in a balance between these rights. In principle, the right to the drinking water and the right to the environment. In principle, they should not be antagonistic. And this is the interesting part, since their rights are at the service of the biota and the human being for their own survival. So they're clearly saying that the right to the environment is at the service of nature and also the human being for their own survival. And so it is an ecocentric approach, very much hand in hand with Consultative Order 23 and the Cajunda ruling.
Votos de
The Costa Rican Constitutional Court has been pretty active. We look at nature with its true intrinsic value. This is 99 with the green turtle. Through the environment, the green turtle was protected, and then in 2000, the Lora turtle. In 2002, the green Amarillo, and then the castors, and then the honey-making bees in 2019. We are talking about some chemicals that were banned because they harmed the bees. And then in 21, there was a wild fauna trails that were protected. As a conclusion, the future of the environmental law is one together with all other human rights. And now, this is at the service of biota and of the human being for their own survival. And with that, I'm over, and thank you very much for your attention. Thank you. We are about to conclude this panel. I will now give the floor to Raúl Campusano Droguett, who is the Academic Director, Master of Environmental Law and Master of Arts from Notre Dame. You have the floor, sir. Good afternoon. Thank you. I will bring in 3 questions related to the relationship between Constitution and the environment, having in mind regulatory instruments in order to prevent or to deal with environmental risks. First of all, what is the effect that this may have in a constitution? Secondly, what is the role of international treaties related to the environment in the constitutional order? And thirdly, what should a constitution deal with in talking about the environment? Let's see if I can deal with all of these in the time allowed. In the Latin American constitutional system, I'd like to bring in 2 data related to the environment. First, the Chilean Constitution was pioneer in consecrating the environment and doing so having in mind basic rights of individuals. The Constitution assures to all the right to live in an environment free of pollution. This simple and direct idea opens up something very important for the country. And once the recovery of democracy happened, then we saw the law on the environment from 94. The constitutional rule says that the state is in charge of watching out for the protection of the right and the protection of nature. Likewise, it grants a procedural systems for the protection of the environment, habeas corpus. During these years, we can see that the constitutional rule has aged. It has aged, to be frank. New beliefs, new situations, new approaches have all had to do with this constitution for some time now. The growing constitutional proposal was rejected by the citizenship in Chile, contained different environmental items, some of them consistent with the development of the topics, and others that were innovative, so much so that it was going to be called by some by an ecological constitution, as was explained today by a speaker this morning, Mr. Piano. Secondly, during the last few years, constitutions from different countries have reformed or implemented new constitutions after a constitutional process. In these countries, we must mention Bolivia and Ecuador. For Bolivia, the Constitution in Article 33 says that people have the right to a healthy, protected, balanced environment. This right should allow for people and communities of this and the future generations, aside from other living beings, to develop normally and permanently. The text has different allusions to the environment. Some have to do with agro-environmental court, others have to do with economic, indigenous, territorial spheres, and others. There's a full article on the environment, natural resources, and territories. In talking about Ecuador, the situation is similar. Article 86 of the Constitution says that the state will protect the right of a population to live in a healthy environment, a balanced environment, ensuring sustainable development. It will watch out so that this right is met, as well as the preservation of nature. As in Bolivia, the Constitution has many paragraphs related to the environment. It is pioneer in some things, such as the rights of nature. Indeed, Article number 10 of that Constitution says that people, communities, peoples, nationalities have guaranteed rights in the Constitution and in the international agreements. Nature will be subject of the laws recognized by the Constitution. Article 71 says that nature, or Pachamama, where life takes place, has a right for continuity and the maintenance and the respect of vital cycles. The question that we make right here has to do with the effects of mentioning the environment in a constitution. The first thing that we'd have to say is that these trends reflect the progress witnessed in Latin America in the last decades, as well as the rest of the world, of the new awareness of the environmental challenges for the environment, including for all living beings. As a matter of fact, a few decades back, the priorities did not include the environment. Nowadays, that is a fact. The new constitutions in Ecuador and Bolivia are clear evidence of this new paradigm. And we see that life in society is built from an ecologic platform, and this has consequences in all aspects of life. Bolivia and Ecuador, brother countries with whom we share so much, have diverse ecosystems and different experiences that we can learn from. Their constitutions express different environmental, ecological issues, especially the delicate interrelation with other topics such as indigenous people, natural resources, water, territories, and governments. Likewise, these processes have much we can learn from. We can also analyze the weaknesses and problems. Yale has brought in an index of environmental performance throughout the world. This is done together with Columbia University, and it's published every 2 years. During the edition from 22, we can read that the best environmental performance was seen in Denmark. Now, Danish constitution doesn't talk about the environment. The same happens with Japan, Ireland, and Australian constitutions. They are ranked at 24, 26, and 17. For the Netherlands, their constitution has one standard having to do with environment. Article 21 says that the public state will watch out for the protection of the environment. That's it. That's all it says. And the Yale index ranks Netherlands as number 11. Now, if we go and look at Bolivia in that Yale ranking, it ranks 99, and Ecuador 66. An additional piece of data, Chile has dropped in its ranking in the last few years. In 2010, Chile was ranked 16, leading Latin America, and with a good standing vis-a-vis the rest of the world. In the current year, 22, Chile was ranked 66. It's true the methodology has changed, but the trend is clear, and it should be used as a warning for Chile. What can we conclude here? How can we interpret this information? First of all, what is evident? There doesn't seem to be a direct relationship between the way the environmental issues are ruled and seen in the Constitution and the performance of that country. Some well-ranked countries don't have a lot of articles on the environment, whereas other countries have many items and articles related to the environment, but they are not well ranked according to this Yale index. Naturally, deeper analysis is needed to make interpretations and to draw conclusions. Nevertheless, it would seem that environmental performance requires more than just constitutional mention. We could believe that it is needed, but not enough. Others are needed, such as, for example, environment laws that are appropriate, as well as good public environmental policies and good oversight systems, as well as a citizen culture that has to do with environment, that involves environmental duties, as well as an environmental ethics that is shared by all citizens. The countries that have a high level of environmental performance and no constitutional article coincide in that they have included in their legal systems different international systems, such as the Convention on Biodiversity and others. And the second question has to do with international treaties and their role in the institutional order. Chile, as many other countries, has ratified different international treaties having to do with environment. And what is the role of these treaties in the legal system of the country, and what is the regulatory hierarchy that they have? Could this make invalid, for example, what Paris Accord says? That is possible if we understand the treaties as going after the Constitution. We can take a look at the constitutional ranking. And here, there's a block of rules that would relate our Constitution with these other treaties and would solve the issue of hierarchy. There's Article 27 of Vienna having to do with the rights of these treaties. And naturally, there are many treaties involved. This has to do with environment, human rights, economic treaties, commercial treaties, and they all have their own system, and they bring in different reflections in the international community, a community that Chile is a part of, by the way. These are the agreements that have been built by all, and this is the best that has been accomplished in terms of deliberation and democracy with all of the diversities involved.
Legal, economic, and historical measures, but above all, there are value-based and identity reasons. Who we are and who we wish to be. How do we see and understand the international community? Collaboration or isolation? Final words. There are major challenges ahead for humanity. The climate change is very important, but it is not the only challenge. Also, we must face others, such as, for example, the fight against poverty Or is that no longer relevant? How will we do this? How do we create wealth for everyone? How do we defeat misery in Chile and the world in the fight against future pandemics and threats to peace? Caring for peace and human rights is a task that should guide our agenda and our conviction. The horrible specter of war, as the battles of Camus are there, latent, always able to be activated. How to address ecological challenges, that depends on how we take a look at the glass. One possibility is to see the environmental challenge as a sum of prohibitions and punishment. Do not do this and punish who does. Another possible path is to rescue and renew the idea of sustainability and sustainable development. Very inspired people raised this idea, and we have let it drop, perhaps too soon, without giving it a real chance. The environmental challenge may be addressed as an opportunity for our intelligence, our values, and our will to cooperate and collaborate, promoting science and technology, imagining new alternatives, exploring and inventing. We have done it in the past, and we can do it again in the future. Collaborate among ourselves, all of us, raising a new ethics, a new bioethics, understanding that we too have duties towards nature, living beings, and our comrades, sapiens, to fight, to join in until it is an odyssey that addresses all themes and moves towards life and society truly better for everyone. And lastly, and to conclude, the new constitution, I believe, should be a cosmopolitan constitution in the sense described by Matthias Kuhn, part of the world of the major contemporary agreements legally materialized through international law. And for this, it should include the concept of constitutional bloc from comprising current international treaties and as a cosmopolitan and contemporary vision of the future. And if you allow me, briefly, with a combination between what we want, what we all want, and an offset by the practicing of power by future governments. I would like to end picking up what was said this morning by Chief Justice of Chile, Juan Eduardo Fuentes, regarding the role of environmental justice in our lives, and especially his call to reflect on which are our hopes. And I would add, stubborn hope. Thank you very much. Thank you, Professor. And now we will have a period of Q&A. This question is for Professor Mario Peña. The greening of human rights are sustained in a direct application of the Constitution. There is a direct application of the Inter-American Court, such as consultative opinions, international treaties. Yes, the Constitution of Costa Rica is an old constitution of 1949, and the constitutional reform of the environment arrived in 94, since the first illegal environmental revolution that we're talking about now. And basically, it's almost as though there are 2 or 3 articles in the Constitution of Costa Rica on the environment, and that is everything. It is very laconic. It recognizes a healthy environment and economically balanced, and claims the reparation of the environment. And last year we included a 3rd paragraph on the human right to life. And that's it. And as of then, it has developed through by the principle through constitutional jurisprudence, and the rulings are effective. And so it obliges the entire system to take them in the preventive one, precautionary, the whoever pollutes pays, reparation of the environment, and more recently from 2008 onwards, progressiveness. And so we got the Constitutional Chamber to recognize this for concrete cases. Yes, the constitutionalization of the environment is very, very relevant in these cases. That is what the Constitutional Chamber has done. Basically apply the Constitutional Article 50, which the only thing it says is that it guarantees the right to a healthy environment. And then based on that, they do all these other developments, doctrinary, jurisprudential. Also considering a very important aspect that I was commenting to Raúl, that in Costa Rica, international human rights treaties via constitutional interpretation, once again, have the same rank as the political constitution and are even above the constitution when they guarantee more. That is important in the sense that we can speak of a constitutionality block that includes the political constitution, the constitutional principles raised by jurisprudence, and well as the international environmental treaties. And then the interesting thing is that since 1990, the Costa Rican Constitutional Chamber understood that the right to the environment was a human right and balanced international treaties on the environment to international treaties on human rights. And so then, as of 90, it has a constitutional rank. All of these international treaties on human rights and the environment, and that, of course, have been applied since the 90s. Almost all international treaties that have been signed by Costa Rica, it is Costa Rica has signed the great majority of international treaties on human rights and also the environment. And this was done exactly the same by the Inter-American Court. The Inter-American Court said that the environmental human rights was equivalent to the common use of human rights. And our higher courts resort, as a rule, to jurisprudence of the Inter-American Court in order to justify their decisions. And that is this dialogue among courts that we were talking about now. Thank you, Professor Mario. And now for Carolina Restrepo. How can the Colombian Constitution, how it has permeated the reality of this country and affected the customs of people in terms of changing the existing institutions? Yeah, thank you. I believe that this brings me to repeat one of the conclusions that I wanted to elaborate on further, but I did not have sufficient time. I believe that the most important, and Oscar also mentioned this, is a series of articles and provisions of the political constitution of 91, and that it has empowered communities and populations affected by different projects, activities, and so on, that exploit natural resources. And they have been empowered in different ways, all the way from social mobilization and civil organizations that have represented these communities, the communities themselves organized through civil organization, but there are also legal organizations that represent them to make their situation visible before the exploitation of natural resources. And this also has created tensions with large enterprises, large multinationals that arrive being stronger than the government itself. And so therefore the relevance of the judicial action and protection, which is a way of protecting classic fundamental rights, life, physical integrity, and different freedoms. But the Constitutional Court over the years have developed far further the tools for protection. And the catalog has been extended, and then the Constitution protects collective rights, and the court, through 30 years, has interpreted from the connectivity of individual rights and collective rights, and to, as I was saying earlier, to reach an ecocentric approach, and then, yes, recognize the category of the right to the environment and everything that this entails. And to conclude, I believe that this has been the important thing of this environmental charter. Thank you, Carolina. Professor Peter Tobias, are you there?
Yes, I'm there. Thank you very much.
Yes? Great. A question for you. Which are the constitutional elements that may explain the differences in legal reasoning between the cases of the Netherlands, in the case of Genda, and Germany, Neubauer?
Thank you very much for this wonderful question. I think the Dutch courts and then the German Federal Constitutional Court had before themselves different kind of claims. I think the Dutch court had before it a claim from the population and a number of individuals in the Netherlands, basically asking for more ambitious emission reduction targets. And those claims were basically based on life and health as constitutional guarantees. And the claims were put forward by reference to the Paris Agreement, basically. In Germany, the claim was made more specific. It was
Específicamente abordaba la situación de las personas más jóvenes, quienes se enfrentan a una política de cambio climático muy relajada para los próximos años, hasta el año 2030, y con una consecuente resultado de que Alemania posteriormente tendrá que tener una reducción o metas de reducción de las emisiones mucho más estrictas. Y el reclamo era específicamente la distribución desigual entre los alemanes más mayores que actualmente pueden disfrutar de contaminar el medio ambiente, porque hasta el año 2030 las restricciones no son tan severas, y entonces posteriormente la población más joven tendrá que estar mucho más sujeta a restricciones o reducciones de emisiones mucho más estrictas a fin de lograr la meta del 2050. Y irónicamente, pero esto doctrinariamente es muy interesante, los demandantes alemanes basaron su reclamo en la libertad de contaminar el medio ambiente, o sea, de poder generar emisiones. Y entonces les dijeron, bueno, sí, se puede lograr la meta en 2050, a nosotros se nos va a permitir una contaminación mucho menor que la población mayor. Por lo tanto, el reclamo es como muy específico, pero se construyó muy inteligentemente a fin de interpretar una cantidad de temas constitucionales alemanes. Entonces, primero, el tema de la protección de las generaciones futuras y los derechos de las generaciones futuras, y que primero le agregó a la doctrina en cuanto a los derechos fundamentales en Alemania, diciendo que también podían presentar un reclamo en base a los derechos fundamentales a la luz de los desarrollos a futuro, cuando muchos pueden demostrar de que son inevitables. Y los demandantes tuvieron éxito en demostrar que, mientras que el gobierno alemán y el parlamento están muy relajados en este minuto, tendrían que ser ellos tendrían que ser mucho más estrictos después del año 2030, cuando esto afecte específicamente la generación hoy más joven. Y esto es un reclamo como una afirmación muy interesante. Irónicamente, se basó en su libertad de contaminar el medio ambiente y como parte de la libertad de hacer lo que uno quisiera. Y es una disposición específica bajo la ley alemana y es el principio. Y, 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 y ya se han mencionado los principios, pero el artículo 20A de la Constitución alemana está el principio sobre la protección del medio ambiente, incluyendo para el beneficio de las generaciones futuras. Y la Corte tomó esta parte de las generaciones futuras para interpretar los derechos fundamentales. Entonces, esto ya era en sí mismo interesante, pero también demuestra que los derechos no redactados se pueden utilizar a veces de dos maneras, como en cuanto a la propiedad, que también ha jugado un papel en este sentido. La propiedad puede ser la base para reclamar el derecho a contaminar, o sea, utilizar su propiedad, y al mismo tiempo también puede ser utilizado como un derecho en contra de la contaminación, y que si yo quisiera proteger la forma en que yo utilizo mi propiedad, entonces la contaminación podría ser perjudicial. Entonces yo creo que la gran mayoría de las libertades fundamentales ordinariamente pueden ser utilizados para ser ambientalistas y también el contrario. Y, y este caso de Alemania sucedió, pero no fue tanto la Corte que se defendió distinto el caso en Holanda, sino que fue la forma de estructurar la demanda y que juntó estos dos tipos de desarrollo.
Ahora vamos a la última pregunta para el profesor Raúl Campusano. La pregunta es la siguiente. Atendido.
The question is, in view of social environmental conflicts in Chile that have grown in the last few years, we have in the new constitution perhaps a paradigm, or would it be enough to continue only with a cultural change for the protection of the environment? Well, it seems to me that the social environmental conflict has grown not just in Chile, but throughout the world. If we look at what's happening in other countries, we may tell that there is an increase in the number of a social environmental conflict. So the question should be, how can we interpret this, and how can we go ahead improving the relations between the different desires of society? And here I believe that, as I tried to show in my presentation, adding or not adding things into a constitution may have some value. But believing that just by adding a certain principle related to the environment or a paradigm that to the constitution, that the environmental conflicts will be disappearing, that I believe is being extremely naive. In politics, contrary to the protected world that we academics live in politics, there is a judgment on outcome. Good intentions are not enough. We must be capable of improving things, and there is an ethic imperative, believing in democracy, believing in the people, and in justice. Therefore, what I suggest in my presentation is that the fight to go ahead and to solve social environmental conflicts must go through appropriate legislation, good oversight, and good public policies. There's much that can be done. I must confess that I am proud of what our country has accomplished in the last few decades here. naturally must be done in terms of oversight. But at the end of the day, we are facing an bioethical imperative. And this is something that brings the question to what the state and the constitution to do and what we people can do. What can we do in order to improve our environment and social justice? Thank you. Well, with this, the second panel is closed.